May I call to order the Bills Committee on Patents, Amendment Bill 2015. First, we need to elect a chairman. Can we have nominations, please? A valid nomination must be made orally by a member and be seconded at least by another member orally and must be accepted to the member nominated. Mr. Sin Chung Kai. I nominate Mr. Martin Liao. Any seconder? Dr. Lo Wai Kwok seconds. Mr. Martin Liao, do you accept nomination? I do. Any other nominations? If not, Mr. Liao, would you please take the chair?
OK， 我想請問各位委員。
Let's ask members whether we need a deputy chairman. Thank you. We are going to discuss the Patents Amendment Bill 2015 today. The background brief is provided by the Legislative Council Secretariat, but also there is the Legislative Council brief provided by the administration. The Legal Service Division report is LS 9/1516, and the Legislative Secretariat's paper is CB 1-21902. Before members ask questions, I'd like to ask the administration to introduce the bill to members. The introduction will take about 20 minutes. There will be a PowerPoint presentation. Thank you, Chairman. Let me now briefly introduce the Patents Amendment Bill 2015 to members. Now, what is a patent? It protects inventions and prevents others from doing acts like manufacturing, using, selling, or importing patented inventions. Now, what are patentable inventions? These are novel. They involve an inventive step. They are susceptible to industrial application, and they are not within the excluded categories. By excluded categories, we mean inventions that go against public morals. We have been making use of registration of patents ordinance, but because of reunification in 1997, that ordinance was repealed, and the re-registration system would mean that these were patents already registered in the UK or in Europe. And then after 1997, we made use of the patents ordinance to take the place of the last one. And this is based on the report submitted by the Patents Steering Committee. According to this ordinance, there are two types of patents. One, standard patents, where the maximum term of protection is 20 years, and short-term patents with a maximum term of protection of 8 years. The background is that the current patent system, including standard patents, and we go by the re-registration system. And first of all, patents have to be granted by one of these designated patent offices first, State Intellectual Property Office in the mainland, or SIPO, or the UK Patent Office, or European Patent Office designating the UK. An applicant in Hong Kong for a standard patent has to make, first of all, a corresponding patent application in one of these designated patent offices before they can apply for one in Hong Kong. And an application for a standard patent is made in 2 stages. 1, request to record, and it has to be filed in Hong Kong within 6 months after the date of publication of the corresponding patent application in the designated patent office. And second stage is request for registration and grant. As it is said here, it is filed in Hong Kong within 6 months after the date of grant of the patent by the designated patent office or publication of the request to record in Hong Kong, whichever is the later. Since we make use of a re-registration system, the Hong Kong Patents Registry only conducts formality examination without doing substantive examination. And then there are short-term patents. These can be made directly in Hong Kong. A search report has to be filed. It is one of the main documents, and the Hong Kong Patents Registry only conducts formality examination without substantive examination being conducted. This is a faster and less expensive means of seeking protection suitable for inventions with shorter commercial lifespan. Regulation of patent practitioners under the current patent system. We only have a limited regulation. The registrar has limited regulatory powers over certain acts of patent agents in connection with a patent or a patent application. For example, they are not residing in Hong Kong and they do not have a place of business in Hong Kong, or he has been convicted of a criminal offense in Hong Kong. With regard to professional requirements or qualification, we do not have statutory regulation on such. With the advance of times, we think we need to review the patent system. In October 2011, we kick-started that review and consulted the public. At the same time, we set up the Advisory Committee on Review of the Patent System in Hong Kong. The chairman is the Honorable Andrew Liu. And the members comprise government officials, legal professionals, patent practitioners, academia, R&D, and industrial sector representatives. The Advisory Committee submitted recommendations to the government in December 2012. They established an original grant patent or OGP system for grant of standard patents while retaining the current re-registration system. Secondly, that we should retain the short-term patent system with suitable refinements. And 3, that we should establish a full-fledged regulatory regime on patent agency services, which should be the ultimate goal in the long run, but it should be achieved in stages with possible interim measures. In February 2013, the government accepted the strategic recommendations of the Advisory Committee, and we also briefed members of the proposals and had the general support of members. And we briefed the panel on commerce and industry in February 2013 and April 2015, and also we applied to the establishment subcommittee for some posts to be created in order to follow up the work that was in January 2014. In this Patents Amendment Bill 2015, the key proposals are: number 1, introducing an OGP system for grant of standard patents; B, refining the short-term patent system; and 3, implementing an interim measure for regulating local patent practitioners pending establishment of a full-fledged regulatory regime in the long run, and the other technical and miscellaneous amendments. Introducing an OGP system. An applicant will be enabled to file an application directly in Hong Kong without first obtaining a patent from any designated patent office outside Hong Kong. As I said, we would retain the existing re-registration system. The bill sets out the basic procedures for an OGP application. Upon receipt of an application, the Registrar of Patents will first examine the application to ascertain whether it complies with the requirements for a filing date to be accorded, and examine on the formal requirements, and if there are deficiencies, the applicant will be given an opportunity to correct the deficiencies. Number 3, if the application passes the formality examination, the application will be published after expiry of the prescribed time. After publication of the application, the applicant must request the registrar to carry out substantive examination of the application. And third parties may file their observations on the patentability of the invention within the prescribed time. The registrar must consider the observations when carrying out the substantive examination. The registrar may raise objection if the application does not fulfill any examination requirement. The applicant may file submissions or propose amendments to the application to address the objection. The applicant may also request the registrar to review the objection. If the applicant does not comply with examination requirements, the application will be refused. If the application upon substantive examination is found to satisfy all the examination requirements, the registrar would grant the standard patent and publish the patent. On refining the short-term patent system, we'll relax the restriction on the number of independent claims. And we will set out the basic procedures for substantive examinations of short-term patents after grant. The procedures are generally similar to those for substantive examinations for an OGP. The registrar must revoke a short-term patent if it does not comply with all the examination requirements. In refining the short-term patent system, we will seek to prevent the abuse of unexamined short-term patents. A patent owner, when making a threat of infringement actions, must provide certain patent documents upon request. A failure to provide such documents will render the threat groundless. Refining the provisions about the burden of proof in groundless threats proceedings in relation to short-term patents. And before starting the proceedings, a patent owner must make a request to the Patents Registry for substantive examination. And once it is submitted, it cannot be withdrawn. The patent owner's application for an interlocutory injunction must be accompanied by evidence to establish prima facie the validity of the patent. And interim measure for regulating local patent practitioners. As we said, a full-fledged regulatory regime covers aspects, for example, the establishment of a professional regulatory body, accreditation, use of titles, professional discipline, training, service monopoly, and statutory backing. The advisory committee has been deliberating on these long-term issues and engaging stakeholders. Further work needs to be done. So we propose making interim measures to reserve certain specific titles which may likely be conferred on qualified patent practitioners exclusively under the future full-fledged regulatory regime. And there are 5 areas which will be looked into, and there will be an offense concerning the following titles: registered patent agent, registered patent attorney, certified patent agent, certified patent attorney, or any other title or description that would likely give the impression that a person's qualification for providing patent agency services in Hong Kong is endorsed by the government or recognized by law. So we do not allow this to be used. So under such circumstances, we will also introduce appropriate exemptions. For example, the use of professional titles such as solicitor, barrister, or foreign lawyer by qualified legal practitioners in providing patent agency services in Hong Kong. And the reasonable use by patent agents in Hong Kong of professional titles that have been lawfully acquired outside Hong Kong. These are exempted.
As for other amendments, most of them are technical and miscellaneous. For example, setting out that inventions relating to second or further medical uses could be regarded as new, novel, so as to make claim drafting for these inventions simpler and more direct. And the proprietor of a standard OGP or a short-term patent in respect of which a certificate of substantive examination has been issued may apply to registrar or the court for amending the specification of the patent. On developing indigenous capacity for conducting substantive examination, Hong Kong has yet to develop this kind of capacity. We lack the practical knowledge and experience, and we have to build this kind of capacity gradually. Intellectual Property Department entered into a cooperative arrangement with CITB in December 2013, under which CITB agrees to provide technical assistance and support in conducting substantive examination and manpower training. The statutory powers relating to patent grants are solely vested in the registrar. We plan to develop in incremental stages in-house capacity in conducting indigenous substantive examination in the medium to long term. As for other implementation tasks, we will draw up proposals for subsidiary legislation to be made under the bill. We will draw up examination guidelines. We will set up a new electronic system as well as train patent examiners. Conclusion. The bill implements the strategic recommendations made by the Advisory Committee, and the legislative proposals are mainly procedural and technical in nature. In formulating the bill, we have taken into account the patent systems, practices, and procedures generally established in the international community. Representatives of the major local patent professional bodies have been consulted on certain provisions, and their views have been considered. The new patent system is an integral part of the local IP protection regime, and is also an important infrastructure for promoting the development of Hong Kong as a regional innovation, technology, and IP trading hub. Comparing with economies with development paths similar to Hong Kong or of comparable size with Hong Kong, it is relatively late for Hong Kong to start developing its own OGP system. So we appeal for members' support for the bill. We hope that its proposals can be implemented as soon as possible. My presentation ends here. Thank you. I would like to declare interest. The chairman of the Advisory Committee on Review of the Patent System in Hong Kong, Mr. Andrew Liu, is my elder brother. Who would like to ask questions? Mr. Lo Wai Kwok. Chairman, in principle, I support that Hong Kong develop an OGP system. But there is an important point. For the OGP, will it be acceptable by other or recognized by other countries? Just now, the government told us that CITB has discussed this with Hong Kong government. And according to the paper, other than CITB, the patent from CITB and the patent from UK, we would re-register them in Hong Kong. That means we recognize those patents. So would there be a reciprocal arrangement in the future? And second, as for the bill, I do not know whether the registration rate has been designated under the OGP system. I want this to be made clear because we want the applicants to know whether this is a rate affordable. If it is too high, would the applicants choose other countries to file their application? Then they can save the money of doing it in Hong Kong. Okay, there are two questions. Thank you, Chairman. First of all, for the first question about reciprocal arrangements, as for a patent system, it is something very local. And among countries and regions, there is no reciprocal arrangement. But Mr. Lo doesn't have to be worried. CITB is cooperating with us, is very experienced, and is one of the 5 major designated patent offices in the world. So we are confident that our patents will not meet a lot of obstacles. As for the fee concerned, we will adopt the user pays principle, and we are very careful about setting the rate level. When we do the calculation, we will make sure that it's affordable. But at the same time, we will have to follow the user pays principle. Maybe Mr. Chang can supplement. Thank you for your question. With regard to the fee, I can give you some more information. In the bill, there's no mention of fee level. According to the existing practice, we will set out the fee level in the subsidiary legislation. So under the new patent system, all the new charges will be set out in the subsidiary legislation. And there is another point that I would like to add. We understand that members and the public are very concerned about the level of fees and charges under the new system, and they want it to be pitched at an affordable level. Now we are still doing the calculation. Of course, when we do that, we would take into consideration different factors. Just now, the Undersecretary has also mentioned it. That is, our principle is user pays. We will take different options and viable options into account, and we hope that our fees and charges are competitive and affordable. And I can give you some information concerning overseas fees. In the international community, there is no standardized fee level. The range is quite big. Well, for the mainland, the patent application fee would be about 5,000 to 6,000 Hong Kong dollars. As for Singapore, it would be from 9,000 to 20,000. As for Europe, it's 40,000 Hong Kong dollars. So when it comes to fees and charges, of course, we would take reference from the other countries' fee levels, and also we would look at Hong Kong's situation, as well as the future utilization rate of the OGP system. After we've decided on the relevant levels, we would immediately report to the Legislative Council. Well, about the first question, I have some other follow-ups. Now, in the international community, there is no reciprocal arrangement when it comes to patents. In Hong Kong, we have a re-registration system. This has already delineated that, because now we have some designated patent officers which we would re-register their patents. And in Hong Kong, we only do formality examination after the patents have been granted by such patent officers. So it means that we respect the levels of these patent officers. So that's why we do not have to do substantive examination, and we just do formality examination before re-registration. So in the future, after launching our own OGP system, if our patents can be treated in the same way by other countries, then it would prove that our level is also recognized by other countries. We will be moving in that direction. Otherwise, when applicants get their patents in Hong Kong, when they go to other countries, they have to apply again, and that would be a deterrent. Well, I would like to reiterate, as for mutual recognition arrangements, we do not have that in the international arena. We just have a so-called highway for patent application. That is, we would have connections with certain patent offices, and if patents have been granted by such offices, then their registration in Hong Kong can be sped up. Well, I don't think we should dwell on the term of mutual recognition. I understand that it's not a mutual recognition, but we are talking about the formality examination. It means that when the patents are granted by some other designated patent officers in Hong Kong, we already recognize such patents. So let us not dwell on the arrangement of mutual recognition. Well, there are historical reasons like this, because each country would have its own local examination system. And Hong Kong has its own examination system. We hope that we are of a high level, and then we can talk with other countries, hoping that the so-called highway of patent examination can be built so that time and resources can be saved. Now that many countries' patent offices are already doing this, that is, they would adopt the concept of building such a highway so that they would speed up the examination of each other's patents granted. Mr. Wong Yuk-man. Well, the government always have legislations which inviting criticisms. Now, for this bill, it says that major amendments will be made to the existing patent system. Now, we only have a very short time left before this LegCo expires, and we still have the Christmas holiday, Chinese New Year holiday, and then in March, many members will have to go to China for CPPCC meetings and NPC meetings, and there will not be enough members here at the Legislative Council. And now you're setting up a bills committee. You want to rush this bill through the council. And members have raised a lot of concerns about this new system. Later on, I will also ask a lot of questions. And when it comes to a clause-by-clause examination, it will also take a very long time. I hope the government won't do things like this. You have to look at our timetable. Why do you want to rush it through the LegCo? We just have several months left, but now you are introducing major amendments to this piece of legislation. Well, if I have the time, I will put together numerous CSA. I can assure you that this cannot be passed within this term.
You have to learn lessons. Remember the copyright ordinance. Mr. Wong is here. You have vetoed 900 CSAs put forward by me, but then the chairman may not be like you. So we need a careful scrutiny of the bill. I need to state this for your information. I know what I'm going to say will not be very effective, but this is too rushed. Okay, let me talk about the bill itself. In principle, we support the proposed establishment of the OGP system. This is part 3 in the bill, but I have certain concerns. As a member was saying, number 1, since the patent system is subject to territorial control, you have to explain what happens after the amendment bill is enacted, and that is mutual recognition with patents granted in other jurisdictions. You really have to explain that. Secondly, I have questions for these Right now, under the standard patent system, there are 3 designated patent agencies, 1 SIPO, 2 the European Patent Office, and 3 the UK Patent System. According to the Patents Ordinance Section 8, this will be designated by the Chief Executive in Council. What is the policy for such designation? And also, why is the US system kept out of the designation? If the OGP system is supported, it will run parallel to the standard patent system. And how will the new system affect the existing system? And Mr. Wong, actually, for the European Patent Office, it is only relating to the designation of UK patents. Undersecretary, I'd like to stress to Mr. Wong that in fact we have been doing our best to get on with the work. It is not that we want to rush this through and propose this bill when there are only a few months to go before the end of the session. Drafting the law took time, and we also had to consult the stakeholders, so we are trying our best to do it. Is it that you don't want to have this completed and passed within the session? Well, no, as I said, I certainly would like the bill to be supported and passed within this legislative session, and I hope members can really give us a hand. By giving you a hand, we are here to rush this through with you. After scrutiny, we don't raise any points, you mean, so we rush through the bill with you? No, we are very prepared to answer members' questions. It will not be a rushed decision. That is why we are here to take members' questions. You mentioned the territorial control or limitation. As I said, the only thing we can do is to establish our own GP system, and then we need to have the international arena or community assign a status to the OGP so that we can also set up a patent examination highway to facilitate the obtaining of patents of Hong Kong applicants in other places that we have kept out the US. Actually, historically, we have designated 3 patent offices. We recognize the patents granted by these 3 patent offices, and they are the existing authorities in our law. And when we have our OGP, we propose to preserve the re-registration system because during the consultation period, the majority views said that we should retain the re-registration system because it is faster and less expensive. After the bill is supported, there will be parallel systems. We have the OGP, and also we are going to preserve the existing re-registration system. The second question is about the difference between the OGP and the systems under the treaties. For example, the Trans-Pacific Partnership. Would there be any interface problems? On the 1st of July 1997, the relevant treaty applies to Hong Kong. Mr. Zhang, please. Thank you, Mr. Wong, for the question. With regard to the Patent Cooperation Treaty arrangement, actually it has applied to Hong Kong at the reunification stage. I'd like to say that the existing system and the future OGP system are not in conflict with the PCT. That's the first point. Secondly, I'd like to add to what the Undersecretary said, and that is territoriality and also how the OGP system will affect the existing patent system. Actually, patents and trademarks and copyrights are subject to territoriality. Patents registered in Hong Kong are only protected in Hong Kong. The short-term patent system and the re-registration system are also subject to territorial control. how the OGP will affect our existing patent system. In fact, there will be no effect, since we are going to preserve the re-registration for standard patents. The OGP is just another channel for applicants to apply for standard patents which have a protection period of 20 years. In other words, under the future system, if an applicant applies for standard patents, he can use the re-registration system, or he can apply directly in Hong Kong without submitting applications to the 3 designated patent offices overseas. We give applicants a choice when standard patents are applied for. So there is no conflict with the re-registration system. What about the TPP? Will we join it, or will there be any interface issue? Chairman, thank you for the question, Mr. Wong. He mentioned the Trans-Pacific Partnership Agreement. Well, that partnership mentions measures on the limited period of using certain information on patents. At the time, we still need to look at the actual operation of the TPP. We cannot see how the TPP will alter Hong Kong's patent system. It is an international arrangement, and it has to do with international cooperation on intellectual property. Of course, we will be keeping close watch of international developments. And it can be said that the TPP has no direct impact on the existing system and the future system. What about the fees? The government will go for the user pays principle. Will it dampen or lessen the attractiveness of the OGP? Will that fly in the face of the original intent of the policy? As Mr. Zhang mentioned, we understand that when we seek to set up a system, we need to consider the fees and charges carefully. One principle is for the users to pay, and on the other hand, we like to set the fees so that they would be acceptable to applicants. Right now, we haven't really set fee levels. If the government would like to develop Hong Kong into a regional patent registration hub, you need to, of course, have recognition by the international and regional bodies. But at the initial stage, you should think about subsidizing application fees. In 1995, Singapore already had the OGP system, so and we only had our own patent system in 1997. Now we are setting up a new system, and I think we can consider fees flexibility. I may not know very much about such matters, and you just told us that you haven't really thought about it. The Undersecretary, can you give a brief reply? Mr. Wong, right now we also have some subvention system, and that is the patent application subvention system, and that is for Hong Kong applicants. If they want to apply for patents in Hong Kong or overseas, as long as they are doing it for the first time, they can apply for subvention. Mr. Paul Chair, I don't know whether I need to declare since you also did it. Mr. Andrew Liao, SC, is my master in practice. Hong Kong lags behind other places by many years, and we are trying very hard to catch up. Actually, Mr. Wong had a valid point. We need to make this system attractive at the beginning, so people will choose Hong Kong and the new system instead of sticking to the old system by making another round at designated overseas offices first. Mr. Undersecretary and Mr. Wong said that you collected views during the consultation period, and you said we should preserve the re-registration system whereby applications filed with SIPO and UK Patent Office and the European Patent Office will come to Hong Kong for re-registration. What about registered patents in the US? Will you consider re-registering those? If we want to be a first in certain areas, shouldn't we shake off the shadow of Europe and UK? Mr. Wong. This is actually a fundamental change. We are going to steer clear of the re-registration system, and we are going to have our own OGP. That has been done by many Asian countries, including Malaysia and Singapore. We will have a very quality OGP system. But if we now designate more patent offices, that might not be consistent with our policy objective. And other countries may have different criteria in examining patents. I don't think we should develop in that direction. On the other hand, we should set up a good OGP system. And so we are less bureaucratic on the patent examination highway. This is what Singapore has done since 1995, and we think we should develop in the same direction. Well, I haven't done a detailed study, but looking at the Singaporean example, do they have a sunset system whereby the re-registration system would be phased out gradually so that local OGP system will be given a higher status? Thank you, Mr. Chair. I think I can comment on this. In Singapore, when they set up the OGP, they did more or less what we are doing. They do not have their own examination capacity. They have to rely on outside examination authorities for support, and then the results would be channeled back to Singapore for formal approval. And then in 2013, Singapore has already got its own examiners to examine patent applications. And step by step, Singapore was setting up their own patent system with indigenous examination authority and capacity. It really depends on the capacity in the countries or regions. So patents are of good quality. Maybe Mr. Zhang can speak more on Singapore. Thank you, Chairman. The Singapore experience tells us, well, it set up its OGP in 1995. As Mr. Wong said, at the beginning, they did not have their own substantive examination capacity. It had to rely on overseas patent offices, meaning Denmark, Hungary, and Austria. And these patent offices were helping Singapore do examination for consideration by the Intellectual Property Department of Singapore. And starting in 1995 until 2013, well, in April 2013, Singapore set up its own search and substantive examination unit. So they had that capacity. And locally in Singapore, search and substantive examination can be done. And recently, Singapore also amended its laws to stipulate that all patent applications must be examined by the Intellectual Property Department of Singapore to make sure that these applications are in line with the legal requirements before they will be granted. But before that, it was not like this. The applicant only had to submit a search report from outside patent offices, and then the applicant could decide on the basis of that examination or search report whether or not to go ahead with the application, and that is a system of self-assessment. But now Singapore has done away with that system anymore, and the Singapore Patent Authority must be of the view that the applications in Singapore are in line with the Singaporean criteria first. And if you look at the evolution of the system in Singapore, we can see the following points. Number one, on the OGP system, it takes time. It needs the accumulation of experience before it can mature. And I agree very much with the viewpoint of Mr. Paul Chair, and it's always difficult to make a start. We'd like to do the same. And actually, this is not unique to Singapore. If you look at Macau, and the Gulf countries, they also designated an experienced patent office with a full-fledged or comprehensive international data bank in order to help them kickstart their own patent system. Number two, I know we have taken a lot of time, and I'm not trying to say that Hong Kong must necessarily use a decade before we can have our own examination team.
So an OGP system would have to operate for some time, and then we'll look at the application condition. We will also try to find out whether there is a niche where Hong Kong has advantages and talents. Then we will gradually build up our own patent system. Well, after listening to Mr. Chang, it seems that we are trying to move faster than Singapore, right? Because it seems to me that while you are trying to launch the OGP system, you want to build your own substantive examination capacity and search capacity. But in the initial stage, Singapore relied on other countries, right? In our proposal, we are saying that CITB will be helping us in terms of substantive examination, and will also help us to train talents. So it's not true that we are trying to move faster than Singapore. Each country or place has its own individual situation. So we are not trying to race with Singapore in terms of capacity building. After having our own OGP system, we would seek the help of CITB. So on one hand, they will help us do substantive examination, and on the other hand, they will help us train talents. So we are relying on our country, and Singapore used to rely on other jurisdictions. So is there a political consideration? That's why we are lopsided towards China. We are asking CITB to help us because it's one of the top 5 designated patent offices in the world. And now 60% of our registration application involve patents granted by CITB. CITB has a special capacity because it can conduct examination in both Chinese and English, and that would be conducive to the Hong Kong situation because our applicants can apply both in English and in Chinese. And inventors can make an application locally. They do not have to rely on an agent to go to another country to apply for a patent. So there is no political consideration. We think this is a convenient and efficient way, and this is a desirable arrangement. I would like to follow up, Chairman. We are retaining the re-registration system, and we will still be recognizing the patents granted by the UK and Europe. I understand that China has been progressing very fast. But I think there is a gap here, because when it comes to re-registration system, we're still relying on the UK Patent Office and European Patent Office. However, when it comes to actual substantive examination, we are relying on the State's Intellectual Property Office. We are relying on the system and technical personnel. So why is there such a choice? As Mr. Wong said just now, our major objective now is to build up our own in-house capacity. Now, if we do away with the existing re-registration system, there will be a lot of changes. So it will mean prolonging our patent application, or the building up of our OGP system. So we are now asking CITB to help us in terms of substantive examination and talent training. It will be efficient, and at the same time we are maintaining the re-registration system. I'm asking you, while you seek assistance, why don't you seek assistance from the UK and Europe? I think you should look at the Singapore experience. It's in the initial stage, Singapore tried to remain as international as possible, so it relied on other advanced countries. Now, of course, we want to build up our own in-house capacity, but I don't think we should be too lopsided towards a certain country. We have to look at the international development trend. China is developing very rapidly. Well, they started to have OGP in the 80s, and now is one of the top 5 designated patent offices. It is the biggest intellectual property office in the world when it comes to certain patent applications. In 1997, we only recognized the UK system. 100% of the patents came from the UK, and now gradually there have been changes. And 60% of the patents that are to be registered in Hong Kong actually come from China. So now we are in the initial stage. We want to focus our resources so that we can put together a quality OGP system. So if we can have the assistance of our country, that would be quite ideal. Of course, we would also look at the international development trend. Okay, then I would also like to raise a question. As the Undersecretary said just now, patent protection is territorial. And for a patent attorney, if a client asks him, where should I register my patents, the patent attorney would ask him, where is your target market? You just register there. So in Hong Kong, if we want to build an OGP system, and this OGP system is going to exist parallelly with our re-registration system, so for our client, if he's registered in China or in UK or in Europe, then when it comes to Hong Kong, he would go through the re-registration system. Then he would be protected in 2 places. But if he makes his application in Hong Kong, then his patent is only protected in Hong Kong. So if you have 2 systems existing parallelly, what kind of incentive can you use to lure applicants to come to file the application in Hong Kong. As I said just now, I mean, this is not conducive to establishing our own OGP system. Well, we are keeping the re-registration system because most stakeholders say that this should be the way forward after our consultation. And also, some companies may like to target the Hong Kong market. So if they come to file the application directly, it would be faster and it would be cheaper. Some companies would do that. But of course, if a company's strategy is different, if it wants to register in different countries, then of course it may choose to register in different countries. And it can also apply for re-registration in Hong Kong after getting a patent from the 3 designated patent offices. After setting up the system, we hope that we can convenience Hong Kong companies. They can have their intentions patented right away. Mr. Wong, you meant 3 minutes. I won't be long-winded, and there are not many members here anyway. Just now we talked about the OGP system in Singapore, and it has been implemented for 17 years. Before, it has its own substantive examination system. And just now, Mr. Porcher asked some questions. Now, who is going to train these people? Now, you are saying that the State Intellectual Property Office, CITB, will help us. You want to rely on that office. But it's also your competitor. Have you thought about that? It's one of your competitors. It's not that I am saying this because I am anti-communist. I am looking at it from a pragmatic perspective. You rely on CITB for training talents, and you are using its mode and system. But at the same time, it's your competitor. So what would happen? I think you really have to assess. Singapore has taken 17 years. I don't think it will take us 17 years because we have the help of CITB. And Singapore started in 1995. It has accumulated a lot of experiences, so you would know the advantages and disadvantages. So I don't think it will take us 17 years. I think what Paul Chia said is worthy of our thought. So it's about whether people have the confidence to file their application in Hong Kong. I think there are still a lot of opportunities for us to discuss all this. And now I wanted to talk about the training of talents as well. And about the patent agency, patent attorneys, etc. And you are saying that there will be interim regulatory measures, but these are just interim regulatory measures. What's the ultimate goal? Do you have a timetable and a roadmap with regard to this part? That is about the training of patent agents and patent attorney. As for talent training, we hope to do that as fast as possible, and CITB will help us. As for the details, maybe I can ask Mr. Zhang to supplement. That is about talent training. Mr. Zhang? Thank you, Chairman. With regard to talent training, I would like to take this opportunity to explain to you about the establishment of our registry. Now we have 5 examiners, and they are handling over 10,000 patent registrations in Hong Kong. With regard to the future OGP system, I am sure that our existing establishments would not be able to cope with that. We need people with a technical or scientific background to join us, and they would be handling the application for OGP. In the initial stage, CITB will provide us with technical support and advice. However, under the law, the power of granting patents still lies with the registrar of patents. So in our team, we need technical people to look into patent applications. So when it comes to training, while we submit this bill to the Legislative Council, we would of course look at the resources available to us, and we will also be applying for funding so that the scale of our registry can be enhanced. We also need people with technical background to join us. After recruiting them, we will provide them with trainings. The trainings would include programs that are provided by CITB, and we would also take part in international training programs. For example, the European Patents Office organizes a lot of courses for examiners each year.
And if there is the opportunity, we hope our examiners can have attachment training at overseas patent offices, so they can have training in dealing with cases, and we'll give them training in terms of theory and practical experience. And also, we will continue to provide in-service training, and we are prepared to provide training in stages. This is our initial thinking about training. Mr. Paul Chan. Chairman, I think you asked a very valid question indeed. What can Hong Kong rely on in order to attract people to come to Hong Kong to apply for patents? Remember, in Singapore, they still have the manufacturing sector, and Hong Kong doesn't have that foundation, and we have a very bleak prospect of developing manufacturing industries. So people may do their own sums, and they may want to apply for a patent on the mainland and come back to Hong Kong to do re-registration. As Mr. Wong was saying, we need to have the assistance and support of the SIPO, and then we will rely on them to provide training, and then this may work to the disadvantage of Hong Kong. It's just like training our own veterinarian officers, but then in Hong Kong we do not have any animal husbandry industry, and in the end you are not going to succeed. And as an intellectual property practitioner, I hope we can complete the puzzle. But then the actual environment in Hong Kong is that we do not have the manufacturing sector. We have the I&T Bureau set up all right, but if you need to generate the demand for application for patents, that's quite a different matter. So I'd like to hear from you whether this is a dream or whether it can be realized. If there is no large-scale subvention by government, do you think we can really set up our own OGP system? Thank you. I think it's a chicken and egg question, Mr. Chair. On the one hand, the manufacturing sector takes up a really meager portion of our GDP, and whether it can support an OGP system. But then, after we have our own OGP system, then we can in fact encourage local students and companies to invest in that area, because they understand in Hong Kong we have our own OGP system. In fact, that system will provide opportunities for manpower training in our tertiary sector. Technical students will know they have another career because they can become patent examiners, and that can encourage more people to join the sector, so that the chain involving government, industry, academia, and industry will be able to be really set up. Well, I can't say how this will develop, but then this will, of course, provide an incentive for diversifying Hong Kong's industries. Can we follow up? Have we thought about discussing this with our country, and that is they would really give us all the help we need, that the Hong Kong OGP will be re-registrable on the mainland. So in Hong Kong, we have a more recognized legal system, and when we also have our own OGP system, then there will be more incentive for international investors and local businessmen. So they are willing to come to Hong Kong for OGP, and then they can tap into the advantage of the mainland market. Can we think along those lines? Mr. Wong. Thank you. I think this is a core issue. In 2011, we started to do consultation, and in 2013, we issued the report, and we indeed visited those issues. But it is a company's filing strategy that is at stake. Of course, they would look at the scale of the market, but in Israel, Finland, and Singapore, which are advanced economic entities, well, they have small markets, but then they also have their own OGP. And if you look at New Zealand, it is a smaller economic entity than Hong Kong, but it has its own OGP system. So the point is, our system should be of quality, and we should have speed and good service, and we should be able to cooperate with other countries so that we have a world-class patent authority. This is how we should develop. And looking at figures, there are about 10,000 applications every year, and about 200 are from Hong Kong local companies. We'd like to expand that figure so local Hong Kong companies can directly register in Hong Kong. The priority date will be accorded according to the filing in Hong Kong, so no one would be disadvantaged. And in the long run, when we have a system, whether we can quicken the examination process with SIPO, that must be our development direction. Have you thought about it? Have you talked about it? Have you tried to secure it? Since we rely so much on SIPO, can we seek better treatment from it? CITB, that has been talked about a long time, but it is still very vague. But have you tried to secure that from SIPO? Chairman, in December 2013, we had the cooperation arrangement, but then now we should focus on setting up our own system. Of course, we need to also deal with that issue. Mr. Charles Mock, first round. Chairman, Mr. Wong just mentioned certain smaller economic entities like New Zealand and Finland, but they have their own OGP. I think the technical and other sectors have supported having an OGP in Hong Kong, but now I think we need more background information. Now, supposing the bill will be supported, we hope the present system will be more effective. Can you show us certain data? You were talking about smaller economies. Do local applications take up the majority of applications, or is it that third tier, fourth tier countries would go to Israel or New Zealand to do application and registration? Of course, countries differ. I don't know whether New Zealand is a gateway to access Australia, like Hong Kong being a gateway to China. But I know that regions and places differ, but I'd like to listen more from you. If Hong Kong science and research companies will put more investment on science and research, and then they can benefit from the system in Hong Kong, then I'd like to hear more about that. And also I'd like to follow up on another part of the bill. Right now, a lot of R&D is done by the government. I can look at the list of deputations to be invited. Many of them are R&D centers. Under Secretary, I think a month ago you were responsible for these centers, but now they have been hived off to the I&T Bureau. I think you still remember what they're doing, right? So if that's the case, do you think these bodies will apply for patent registration in Hong Kong? Or is it that since they are familiar with the patent system in China and in the US and they'll continue to register there? How can you encourage these bodies to make use of our own direct registration system? Will there be policies to promote this? Under Secretary, I can answer the second part first. Mr. Mok, you mentioned the 5 R&D centers. They have already got patents for some of their own inventions. Later on, when we have our own OGP system, as Mr. Wong was saying, as long as we do it well, we do it quickly, and if the system is of quality, I do believe that they will apply for OGP in Hong Kong. As for your first question, maybe I can defer to Mr. Wong to give you the data. I can supplement. We looked into that 2 years ago. Actually, it depends on the stage of development of a country, whether or not they have the OGP. In Malaysia, until 1986, they re-registered the UK, and then Brunei by 2010, and then Singapore 1995. And which places still have re-registration systems? We were trying to look up, and we found it was like Bermuda, Cayman Islands, Fiji Islands, and they are still using re-registration systems. We can see that when the economy develops to a certain stage, and if a place or country thinks that innovation and technology are important, then they will go for their own OGP system. This is actually a piece of the overall puzzle. And that is why we think Hong Kong should develop in this direction. After doing consultation, we decided to do this even if Hong Kong has a small market. I think we need to have a macro view of the issue. Well, I go by what you said. I share the view that at a certain stage, Hong Kong should have its own OGP system. But maybe you don't have the information because you're not answering my question. We can go back and dig up the, like Singapore, Malaysia, and Brunei, they already have their own OGP. But what about the proportion of local applications? Are they really attractive to the local people? Does the OGP system encourage development of R&D, for example? At this stage, I'm not questioning the bill at all. That is not the reason for my questions. I'm just saying that if you have the information, it will help to convince the public, and you can also give more encouragement to local R&D efforts, because you can then tell people that it is not just the I&T Bureau, the CED Bureau continues to support this.
We
can look at the experiences in Malaysia and Singapore. Yes, we can supplement the information to members. Yes, but you have to be very careful about something, Under Secretary. I don't think many countries would do this. That is, after they have their own OGP system, the re-registration system would still be run parallelly. I want to get more information from you. Can you tell us some examples? For example, are there very there are many American companies that are filing the application in Singapore because we want to know what will happen after we have our own OGP system. The answer is very simple. If you want to have protection in Singapore, then you have to register in Singapore. What do you say? You have to register your patents in Singapore if you need legal protection in Singapore. Now, if we want to develop our own OGP system, we have to know all these. And Under Secretary, I have another question for you. Even if we have a system, it doesn't mean that all the organizations and bodies in Hong Kong will support that. I think you still have to talk to the new bureau. And later on, when the R&D centers come to our public hearing, we also want to listen to their views. I hope that there can be government's policies to encourage local institutions for R&D centers and university research centers in Hong Kong. Would the government formulate policies to encourage them? Yes, thank you for your view. Any other questions? If not, I would like to consult members. Do you think we should invite members of the public and stakeholders to come to give views on the patents bill? If so, then I think we will be sending invitation letters to the 18 district councils and relevant organizations, and will also place an invitation for views on the website of the Legislative Council to invite views from interested parties. If members think that certain organizations should be invited, please inform the Secretariat by the 8th of December 2015. As for the dates of future meeting, now we will be holding this public hearing, and it is suggested that it be held on the 22nd of December 2015. It's very close to Christmas. And there's another slot, that's the 23rd of December, and it's the same time slot as a PWSC meeting. I'm afraid that you won't form a quorum. I won't be here. Will the clerk consult members first, and we will decide on the date? Well, tentatively, it's fixed on the 22nd. I hope that you will have a quorum because I will be on leave. The time is from 9 a.m. to 12:45 p.m. So the duration of the meeting will depend on the number of deputations attending. Any other business? If not, we will adjourn the meeting now.